Good morning, and thank you for joining us today. This is episode 11 of series 3 of 39 from 39, which is a series of webinars given by the Property, Environment and Planning team at 39 Essex Chambers. My colleague David and I are going to talk in theory for around 39 minutes on certain property disputes which arise between neighbours. We have found that since homeowners and occupiers have been largely confined to their properties with varying levels of strictness over the past 15 months, neighbours' disputes have been on the rise. Whether it's getting hacked off at overhanging branches, or seeking to extend property or maximise space, or renewing boundary features, there have been greater opportunities for disputes to bubble up. The three broad areas that we're going to talk about are on the screen now. They are the maintenance and improvement of property, noise and disturbance, and encroachment by a lessee on land that is not demised to them under a lease. And we're going to try to focus on neighbour disputes from these issues with the neighbour dispute angle. We will leave some time at the end for questions, and we can also pick up questions as we go through. So please do leave your questions using the question and answer feature on Zoom. Before then we start, I just wanted to talk briefly about neighbour disputes and how they're received by the courts. We know that neighbour disputes are often very messy. Parties can become entrenched very quickly. Ordinary or minor issues can become the source of daily tension and altercations. I often find that the comments of Lord Justice Mummery in Wilkinson and Farmer are instructive, and I try to keep those in mind when I'm advising clients. That case, Wilkinson and Farmer, was about the width of a right of way, and it was actually appealed twice. Lord Justice Mummery said this: "The whole exercise has been an uncomfortable experience of unsatisfactory aspects of the conduct and cost of neighbour disputes in the courts. Everybody agrees that, if at all possible, disagreements between neighbours about rights of way, boundaries or whatever should be settled without ever going near a court. In my view, professional advisors have a duty to warn their clients at an early stage about the downside of neighbour litigation, even for a successful party. If the case goes to court, there is, as this case shows, some uncertainty about the ultimate outcome. The case does not always end with a trial. Appeals are possible. What is certain is that at the end of the day, one of the parties will lose and will usually finish up fixed with an order to pay very considerable legal costs. That is not good for the losing party or for the prospect of harmonious relations between neighbours who continue to live next door to each other after the case is over." It's a lengthy quote. I'll just continue the next paragraph. He then said, "The cost and stress of a court case will often result in the further deterioration of already damaged relationships. The parties might be horrified to discover that the litigation has blighted their properties as well as their lives. These cases, which have increased with the rise in home ownership, present priority problems for an overstretched civil justice system. When a neighbour dispute gets to court, there is a risk of it looking relatively unimportant to everyone except the parties. Sometimes neighbour disputes are trivial. Even then, they are potentially ruinous in financial and human terms for both sides." As I mentioned, I find it's always a good idea to keep this case, or at least the sentiments expressed within it, firmly in mind, because neighbour disputes really do get out of control very quickly. What other steps can we take then as advisors? Well, ADR is always an option, and it's an option that we must consider under various professional conduct rules, and also bearing in mind the guidance in this case. What I think is unhelpful is that there's little statutory guidance on ADR. We obviously don't have any mandatory mediation or other ADR that parties must comply with. There is the Property Boundaries Resolution of Disputes Bill, which has been trundling through Parliament for the best part of a decade. You may have heard about it. It sets out a procedure very similar to the procedure in the Party Wall Act for the appointment of a surveyor to determine boundary or right-of-way disputes before getting anywhere close to the courts, and for the courts to apply cost sanctions if parties don't follow that procedure. That's, as I mentioned, not yet law. It's currently through its second reading in the House of Lords, and I'm not holding my breath that it will receive royal assent anytime soon. So in the meantime, it falls upon us to consider how best to advise clients to avoid escalating tensions and costs, if at all possible. I'm going to start by looking at the maintenance and improvement of property, and you may have seen this photo recently. It's partly the inspiration for this webinar. This photo is taken from the BBC News website, but it shows property in Sheffield which made the headlines a couple of weeks back. Occupiers of one property, you can guess which, who had been neighbours for more than 20 years, decided to cut overhanging branches from this conifer, claiming that birds were nesting in the tree and causing a nuisance on their driveway. According to the parties involved, unsurprisingly perhaps, this dispute began to heat up last March 2020 when government restrictions were first introduced. So the result is a rather sorry looking conifer, or half a conifer. In principle, where there are overhanging branches from a tree, a neighbour is permitted to cut back those branches. The same would apply to any roots that extend over the boundary. I would be a little bit concerned though, in this case in particular, but other cases similar to it, where in taking such action and getting a tree surgeon to cut back branches, it damages or kills off the tree, that tree falls. It's very likely that the neighbour whose tree it is, on the left-hand side there, would be able to bring a claim in trespass and seek damages for the cost of replacing the tree. It goes without saying that the parties in that case could have discussed the damage and the inconvenience being caused. It would have resulted in less, perhaps a more visually acceptable outcome than half a tree on the driveway. It does appear there was some dialogue, but as often happens, unfortunately, neighbours take matters into their own hands and decide that unilateral action is their best bet. But the long and short of this is that the neighbour was entitled to do this. It's just, it obviously isn't an ideal outcome for anybody. It seems then in that case that tree surgeons could chop the branches without accessing the neighbouring owner, the tree owner's land. What options are there, though, where you need access to your neighbour's land? There is the Access to Neighbouring Land Act 1992. It is clearly it's an act that's been around for a while, but there are no authorities on this act. There are no authorities whatsoever. So it's difficult to know exactly how some of the act might be interpreted if you brought an action for an access order under it. But you can seek an access order under this act. An owner can apply for an access order where a neighbour is refusing access to their own land. There's a two-stage test. The works that the owner is intending to carry out must be reasonably necessary for the preservation of the whole or any other part of the building owner's land. And the works cannot be carried out or would be substantially more difficult to carry out if access to your neighbour's land isn't granted. The order isn't automatic. The court won't make an access order where it's satisfied that the respondent, so your neighbour or any other person, would suffer an unreasonable amount of interference or disturbance of the use of enjoyment of their land, or they would suffer unreasonable hardship. And it's not possible to seek payment of a reasonable sum for the privilege of access where it's residential land. You can only seek payment from the court for privilege to access your neighbour's privilege to access your land if it's non-residential. As I say, no reported decisions, so it's difficult to see, or it's difficult to know in advance how likely it is an order might be granted where it's opposed on good grounds. What other options does an owner or occupier have? Well, if it's leasehold land, check the lease. In well-drafted leases, and even in poorly drafted leases, in fact, tenants will often have access rights to other land that isn't theirs in an emergency, but also where they want to carry out works to their own property. If hedges are involved as well, it's possible to complain to the council. So this wouldn't have applied in the case of the neighbours from Sheffield because there was a single tree, but where there is a hedge of evergreen trees or shrubs that are getting out of control and more than 2 meters high, it's possible to complain under the Antisocial Behaviour Act 2003. Again, it's getting legal, and you would want to encourage your client, property owner, to speak and enter into dialogue with the neighbour first, but it is possible to seek a remedial notice from the council. The council would issue a remedial notice where trees are getting out of hand or hedges are getting out of hand. When does the Act not apply? Well, despite the Law Commission recommendations, the Access to Neighbouring Land Act 1992 doesn't apply to improvements or where the predominant purpose of the works appears to be improvement to your own land. That's important, I think, because it highlights the need to approach these situations very carefully. Where your client wants to carry out improvements to their property, knowing that their neighbour has no obligation to grant access rights, certainly not under this Act, means that it really is important to keep neighbours on the right side of each other and to explore dialogue rather than self-help or action that is going to lead to court proceedings. I'll now pass over to David on other ways in which access may be obtained.
If we go back to that tree, I had a quick look at the case law, and the House of Lords Authority determines that you are allowed to cut overhanging branches is Lemon and Webb from 1895. But in fact, if you go back into the yearbooks, you see substantial discussion about the rights where trees overhang another property. And you have to, in the eyes of the law, offer up the branches you cut or off the tree and offer them back to your neighbour, because otherwise it would be conversion of your neighbour's branches. Now, I've never done that myself, but it might be something could be seen if it's a valuable tree, such as a fruit tree, it could be seen as a valuable right. So you can see the kind of law we're dealing with is very much encrusted into the common law. So moving beyond trees, sometimes you have a benefit of an easement for access, and it's impossible to characterize these in general terms. But recently been looking at an easement and the case of Rise Gold Limited against Escalate Limited from 2008 came up, where the dominant owner had the right to enter upon such parts of a yard at the rear as is necessary for the purpose of carrying out any maintenance, repair, rebuilding, or renewal. And the owner of the dominant tenant actually erected fencing, scaffolding, and a tower crane for 45 weeks. And that was held to fall within the right that was granted. So easements that allow you to enter onto the land for maintenance or repair can give you quite a lot in terms of access. And of course, last year was the Court of Appeal case in Earl of Plymouth against Rees, 2020 EWCA CIV 816, where a right of entry reserved under a lease allowed the landlord to leave monitoring equipment on the tenant's land on site for a few days. So easements for maintenance and improvement might well be of value. As for the Party Wall Act, that can lead to quite considerable rights if you can establish there is a party wall. You can serve a notice under Section 1 intending to build a party wall. The section also deals with footings, so if it isn't going to be a party wall, we plan to install footings, whereas Section 2, subsection 2, gives rights of repair for party structures. Now, before the webinar, we had a question come into chambers about what happens if you don't know whether or not it's a Party Wall Act structure. And I think, Niraj, we debated this answer and came to a similar result, didn't we?
Yes, David. The question in this case was you have adjacent properties with water ingress through the roof, and works are required to the roof valley, and it's unclear whether, as you mentioned, that roof valley is a party wall structure or not. So in order to ascertain the scope of works and to try and get access to inspect, to work out whether it's a party wall structure, it seemed to us actually, or it seemed to me that one could apply for an access order under Section 1.7 of the Access to Neighbouring Land Act 1992. Section 1.7 provides that if an inspection is reasonably necessary for the purpose of ascertaining, for example, the scope of works, or otherwise in connection with works to the dominant land, that's your own land, then access can be permitted by court order. I don't think it's necessarily the only answer, or it might not necessarily be the right answer, because clearly if there's a controversy over who the roof valley or that part of the roof valley belongs to, there might be an argument that that's not the dominant land, it's not your land, and you therefore can't access your neighbour's land to inspect it.
But I think that raises a point about the Party Wall Act in general, that often those go hand in glove with boundary disputes as well. So that's something to bear in mind. I've often seen Party Wall Act disputes actually be more akin to boundary disputes. A few more points. Crane oversale Leading case of Ass's Anchor Brewhouse against Berkeley House reaffirmed the ad caelum rule, so that if you have a luffing jib crane that's left in free swing mode, and if it starts to oversail neighbouring land, then that is still a trespass, and you might well be subject to an injunction. And on the facts of that case, of course, the owner of the land where the crane was situated had entered into an agreement with one landowner and not another. So it could well be seen as being quite a deliberate and intentional rather than inadvertent breach of the neighbouring landowner's property rights. It's easiest, as we've indicated, to get a license or permission with the neighbouring landowner. And that in itself can lead to issues if there's a premium to be paid as to valuation. I have to say, I'm looking at the Q&As, and the case of Lemon and Webb has provoked some considerable controversy, particularly as to how such hoary old law interacts with the question of tree preservation orders. And one of the questions I have is, what are the options for a landowner where a TPO protected tree is on unregistered land but overhangs your land? Well, first of all, the case law wasn't determined when we had tree preservation orders, and you have to comply with any tree preservation order when it comes to the land. So what I've said is strictly in relation to private law rights. In terms of those private law rights, it wouldn't matter whether or not you know the identity of the neighbouring owner. The ratio of Lemon and Webb was you don't need to give notice as a matter of private law to the neighbouring owner, but you must also be aware, of course, the public law issue to the TPO. I've also got a question. Can you demand the neighbour who owns the tree to lop its branches back to the legal boundary or pay for my costs in doing this work? There's no direct authority on this point. However, in Canary Wharf and Hunter, there was a discussion as to damages for nuisance and the question of abatement, because of course the remedy you're applying here isn't just self-help or help yourself, it's abatement. And it was suggested that you can claim the reasonable costs of abating the nuisance. And of course, if this is a trespass, then you might well be able to claim the reasonable costs of abating the trespass. But given that the value of these lot branches are normally unlikely to trouble the High Court bench, but we're unlikely to see much case law. But I'd certainly suggest that if there is a serious trespass by tree branches, there might well be a remedy via Hunter and Canary Wharf that would deal with that. Now, going on to noise, disturbance, and other tenants, I want to talk very briefly about the case of Duval against 11 to 13 Randolph Crescent Limited. And this case is an important one. It's an important one for management of leasehold properties. This was a converted terrace property in Maida Vale, 2 mid-terrace houses, now a single block, separated into 9 flats, all along leases, 2 leases held by Dr. Duval, a 3rd lease by Mrs. Winfield, and the landlord is also the management company. So you can visualize quite a typical structure, but of course the same law could apply if there are 100 flats inside a building, a multi-occupancy block. 2 terms, and we regularly see these, particularly in residential properties, but also in commercial properties. 2.6, not to make any alteration to the demised premises without the consent of the landlord. So subject to question of reasonableness by the landlord. 2.7, not to commit waste or cut, maim or injure roof, wall or ceiling within or enclosing the demised premises. So the classic absolute prohibition on the tenant to cut parts which are outside the demised premises, or of course those acts which fall outside the more minor works encompassed by clause 2.6. So if we move on to look at the next clause, the landlord's covenant. And this is something that you see quite regularly now in long residential tenancy agreements where there are lots of properties, or even just 2. I've sometimes seen it where there's 2 tenancies out of a single house. First of all, every lease to be in similar terms, not the same, but similar. And then this one, at request of a tenant and subject to payment by the tenant, costs on an indemnity basis, to enforce any covenants entered into with the landlord by a tenant of any residential unit in the building of a similar nature to those contained in clause 2. So if, for example, one tenant is committing noise nuisance and breach of regulations, the idea is you can indemnify the landlord so that the landlord can go after that recalcitrant tenant if you don't have a direct right of action yourself. So if we go on to the next slide, a classic situation, Mrs. Winfield, who owned one of the apartments, wanted a license to carry out works, but went outside clause 2.6 that her works would cut into the structural walls. Dr. Duval asked for the landlord to secure an undertaking for Mrs. Winfield, not at in contravention of clause 2.7. So you can see immediately trying to cut across the landlord's normal right to grant a license, even if they're not obliged to grant a license under clause 2.7. So if we move on to the next slide. So first instance, landlords, as held, had no power to waive any of the covenants in clause 2 without the consent of all of the other lessees. So essentially clause 3.19 says you have to everyone has to enter into covenants. Landlord has to force them, or can be empowered to enforce them if another tenant pays for the enforcement. Now, it might well be said, at least with practical results, particularly if it's a very large multi-occupancy building. And that was essentially the result taken on the first level of appeals, as on Judge Parfit. Landlord did have power to license works that otherwise amount to a breach. And if we move on, but the Court of Appeal took a different stance altogether, held that effectively the landlord couldn't, what would otherwise be, couldn't waive a breach of covenant of clause 2.7, because that would place it in breach of 3.19. And if we move on to the next slide, that result was upheld by the Supreme Court. If we move on just a moment, yes. We have the interaction between 2.6 and 2.7, 2.6 routine improvements, 2.7 much larger ones, going beyond routine alterations and improvements. I've been reading the Woolworth & Co. and Lambert case quite a lot in the last few weeks. It's probably the third time I've had to look at it. And it's quite interesting the way it deals with the interaction between these two kinds of covenants. So excluding from the operation of the absolute covenant anything which falls within the qualified covenant. If we move on to the next slide. So interestingly, the Supreme Court comes back to the question of a covenant for quiet enjoyment. The idea that a landlord cannot give with one hand and take away with another. So you can't, for example, allow a lessee to interfere with support for Dr. Duval's flats. And they were just going to speak a little bit more about noise nuisance. And Suffolk and Mills was, of course, a case about noise nuisance. It was a case about a landlord authorising a lessee to commit that nuisance. Of course, we know after Coventry and Lawrence, normally the landlord would not be liable for a tenant's nuisance unless, of course, they've authorised that nuisance in some way. So if we move on from there, as an implied term, party who undertakes an obligation may be under a further obligation not to prevent the contingency from occurring or put it out of their power to discharge the obligation if contingency arises. So really it's related to the prevention principle. Our purpose is to provide protection to all the lessees in the building. So the landlord shouldn't be putting it out of their power to enforce clause 2.7. Now, the real concern for landlords because of that is quite often, particularly for 125-year lease, you're going to want to allow tenants to carry out works that fall outside rather limited works of alterations or improvements envisaged by clause 2.6. The idea you then have to get permission of all the other tenants certainly has raised some concern amidst the question of management of a block overall. Now, if we move on, I think Neil, I'd hand over to Neil. I should say one particular aspect of that is noise nuisance.
Thank you, David. Yes, one of the key issues from Duval for our purposes is whether we will now see more claims involving noise nuisance and conceivably other types of nuisance being brought as claims against landlords for breach of covenant. Clearly, a flat owner that's suffering from noise nuisance can proceed in nuisance against its neighbour, but often that might not be desirable, might be tricky, might be difficult, it might be costlier and harder than proceeding against a landlord if you're able to do so. Typically, as David has pointed out, it's the offending occupier of the property who is liable in nuisance, not the landlord who has demised the land under a lease. So how does Duval help here? Well, let's consider the not unusual situation where a lease provides, for example, for flooring to be carpet only and an absolute prohibition on changing the flooring to hard floor. That could be a direct covenant, or it could be a covenant or regulation within a schedule to the lease. If then the landlord is asked to grant consent to a tenant to replace that carpet with hard floor, despite there being an absolute prohibition, and the landlord consents, clearly following Duval, if there is then impact noise disturbing the enjoyment of lessees of a neighbouring flat or the flat below, by granting consent, the landlord would already be in breach of a similar mutual enforceability covenant, such as clause 3.19 in Duval. So simply by granting consent when there's an absolute prohibition preventing a landlord from granting consent, it could mean then that there's automatically a claim that could be brought against the landlord for having breached that covenant, granted consent when it shouldn't have done, and therefore that's having caused damage to the flat owner below who's suffering noise nuisance. And it's obviously where there is a claim such as that for breach of covenant, it might not just be damages, it could also be that a neighbouring landowner or neighbouring lessee who's suffering from this noise nuisance could bring a different type of claim, seeking for any licence that's been given to be rescinded, or seeking an injunction to have works that have been carried out to flooring to be reinstated and to be reversed. As David has also mentioned, it's long been considered that a landlord won't be breaching a quiet enjoyment covenant simply by doing nothing, where a noisy neighbour has been disturbing the enjoyment of other lessees, unless a landlord has participated in that breach of covenant, or participated in a nuisance or authorised it, then a landlord isn't going to be liable. And that principle, I think, could be challenged here. It's emphasised in the case of Fuladi, which coincidentally was a decision of Design Judge Parfitt, who was also involved as the appellate judge, or one of the appellate judges in Duval. In Fuladi, which is a decision of the High Court, a leaseholder successfully claimed against occupiers of the flat above for nuisance after disturbance from parties and impact noise. The case was a little bit unusual because the tenants of the block in Fuladi, which is a block in London, could actually enforce covenants against each other. So they had a direct, the tenant suffering from nuisance had a direct cause of action for breach of covenant against its neighbour, which is relatively unusual. You often have that in letting schemes, but it isn't particularly common. Having won below and succeeded in establishing nuisance and breach of covenant against its neighbours, Fuladi then tried to cross-appeal and claimed that the freeholder was liable because it had participated or actively participated in the nuisance. And Mr. Justice Morgan dismissed that argument. He essentially held that simply standing by doesn't mean that a landlord is authorising or participating in a nuisance. The reason why Duval may be important here is that it can provide a gateway for claims by leaseholders against landlords where a landlord has granted consent, for example, to alter property or replace flooring, which then creates a noise nuisance. That is because if the grant of consent is itself a breach and that's caused disturbance, it doesn't seem then necessary for the lessee who's suffering to then go through and have to claim directly against its neighbour. There's also no reason in principle why a leaseholder couldn't succeed where there's a qualified covenant. So in Duval, there was a qualified covenant. There's also an absolute prohibition. And it was conceded in the Court of Appeal by Dr. Duval's counsel that if there's a qualified covenant, this issue doesn't arise. Qualified covenant means that a landlord can choose to grant consent. It's difficult. I don't see why a landlord granting consent to alterations let's go back to the example of floor coverings, where that would create an impact noise situation or create noise nuisance. How could it be said that that is a reasonable grant of consent, particularly if a landlord has obligations to its other lessees to ensure that they can have quiet enjoyment? So it seems that it is possible to argue, and it's more likely to succeed in the type of argument that a lessee can claim against its landlord where a landlord has given consent where it shouldn't have done, and that's created a noise nuisance. If a landlord, for example, hasn't had an acoustic survey carried out or hasn't asked the tenant that's seeking consent to go through various steps to ensure that it will minimize any nuisance or it won't create a nuisance, it seems to me that the granting of consent could be challenged. The other options are less attractive. It's possible for nighttime noise to complain to the local authority relying on the Noise Act 1996, or it's possible to bring a private nuisance claim, as happened in fact in Fuladi. But as I mentioned, in Fuladi, the claimants failed in its appeal, trying to pin liability on the freeholder. Moving then on from noise to encroachment, what do we mean by encroachment? Well, encroachment is a situation where a tenant occupies land that doesn't belong to it under its lease. It belongs to the landlord, or it could belong to somebody else. If you imagine, we have found that there have been a number of cases or number of disputes that have arisen in the last year or so involving encroachment. Let's say you have a loft above a top floor flat, or you have a roof terrace in a block of flats. Possibly it's a patio with storage boxes or a garage or even a driveway. If a tenant isn't entitled under its lease to occupy or to use those areas because they're not demised, it's possible they can lay claim to them under this principle of encroachment. And by encroachment, it's possible that that land that's being occupied by that tenant can be incorporated into that tenant's lease. It's a little bit like adverse possession, but not quite the same, but it's clear, and we'll deal a little bit later with how this can have potentially serious effects on neighbours who may well enjoy rights over the land that's being encroached upon. But the basis of this principle is admittedly unclear. It's either based on estoppel or limitation or a combination or something in the middle of those two, but neither of those possibilities, estoppel or limitation, is particularly satisfactory. One case which suggests that this doctrine of encroachment is based on estoppel or something like estoppel is a case of Perrott. In Perrott, a tenant was demised offices which it occupied under a lease. It also occupied land comprising lavatories next to those offices, and it did that for 5 years. The landlord moaned a little bit about it, but didn't do anything. At the end of the lease of the offices, the landlord claimed for disrepair that existed in the building contained the lavatories, and it was held that the tenant couldn't deny that the lavatories were part of its lease. So let's remember that the lavatories aren't demised under lease. The tenant has been occupying them and claiming that it's entitled to or that it can occupy them. And Lord Justice Denning said that the principle underlying the cases on encroachment is not perhaps strictly on estoppel, but is akin to it. If a tenant takes possession of adjoining property and by his conduct represents that he's holding it under the demise, then if the landlord acts on that representation by allowing the tenant to remain in possession, the tenant afterwards cannot assert that he is holding it on any other footing. But in that case, it appears to have been a positive representation by the tenant that I'm going to occupy this land, stop me, essentially. What if there's no such representation? Can you really found encroachment on estoppel where there's been no representation? A tenant has simply surreptitiously possibly occupied the loft. The loft is accessible in a block of flats. It's not demised to anybody. You can only really get to it through a hatch in the top floor flat. What if that's happened for many years without the landlord even knowing about it? Can it be that there is an estoppel at play? I think it's arguable that that's not the correct analysis of that situation. The other case that I noted there is Secretary for Justice and Chowka Chik So, which is a decision of the Court of Final Appeal of Hong Kong. In that case, the tenants of a fish farm had extended their farm onto other land belonging to the Hong Kong government and had done so for more than 60 years. 60 years in Hong Kong is the relevant limitation period for bringing claims in respect of possession of land. And it was held in that case by the Court of Final Appeal that that long period of possession of land that's belonged to its landlord but wasn't part of its lease extinguished the landlord's title. Now, I'm not clear that that's correct as a matter of English law, because how can a landlord's freehold title be extinguished by adverse possession, essentially, of its tenant? But Lord Scott was the non-permanent judge in that case, And it's possible that his reasoning could be followed in cases in the High Court in England. The difficulty with limitation, as I mentioned, is that it's difficult to see how a tenant can, it's long held been a principle that a tenant can't adversely possess land against its landlord. What is a sufficient period and extent of possession? These are unanswered questions. It seems unclear. If the doctrine is based on limitation and adverse possession, because possibly you need 10 years occupation, as you do under the Land Registration Act 2002, and then a period of 2 years following which you can apply to be registered as owner of that land that you've adversely possessed. Or it could be that 12 years possession debars a landlord from saying, hey, that's my land, I've got freehold title. Can't do that after 12 years. In principle, and the answer isn't clear. It might also be possible that one can apply to the land registry to alter title. So if a tenant has been occupying a loft or a garage, for example, not part of its lease, but has been doing that for long enough, it's possible then, if that, assuming that land is adjacent to its own property, to ask the land registry to alter title to reflect its adverse possession, or at least its encroachment onto that other land. You can easily see how problems can arise between neighbours here, because it may well be the loft is at the very top of an enfranchised building, and all the tenants and who are neighbours may well want to share in the development value of that loft, rather than allowing the top floor flat to simply encroach into it and adopt and annex it to its own tenancy. It's also a problem if easements exist over that land, whether it might be a patio, it might be a driveway, or it might be a storage box, might be understairs cupboard, whatever it is. If tenants and your neighbours or the landowners, the lessee's neighbours have rights over that land, what happens when that land is incorporated into a tenant's tenancy? It seems to me that if the doctrine is based on estoppel or any sort of equitable doctrine, that the tenant encroaching on that land has to take it subject to whatever rights pre-exist. I'll now pass over to David to deal with a slightly different situation where there's encroachment by a lessee onto somebody else's land.
Now, as we move into extra time and penalties, let's have a quick look at adverse possession by a tenant onto a third party's land. And the law here has a very confused and slightly problematic rationale. It's quite clear that it inures to the landlord's benefit if a tenant encroaches onto land belonging to someone else and they are able to acquire by adverse possession. It's seen as if it inures for the landlord's benefit if it's close to the demised land, occupied by a tenant together with demised land. And there's no different intention by the landlord or the tenant within that period of adverse possession. So if we move on to the next slide, this was considered in Tower Hamlets and Barrett case and the case of the Palm Tree Public House. And it's quite usual facts, and we often see this with tenant cases. Next to the pub was a storage area which the tenants used. And if we move on again to the next slide, what had happened was they'd held on to it. Effectively, it had become part of the freehold title of the landlord. And when they purchased the freehold from the landlord, and the dispute was, well, actually, who owns this plot of land? Is it the original freeholder? Is it the freeholder of the pub who sold it to the tenant? Or is it the former tenant who now owns all of it? And it was held as the tenant owns all of it. So the standard provision in Kingsmill Millard was set out. If we move on to the next slide. And Lord Justice Newberger, as he then was, said, well, it's a rebuttable presumption of an unclear rationale. We made it clear it must be very close to the demised land. And if we move on to the next slide. So we could see it's almost a question of natural justice here. It's a question then, if you then transfer the tenancy and you purchase a freehold of the tenancy, so there's a presumption that the new on the sale, that the new tenancy, then it extends to the adjoining land, which has been acquired by the freeholder of the tenancy. Now, the precise ambit of this rule is really quite unclear. What happens if in the relevant conveyance it's absolutely pinpoint, crystal clear what is being sold? The presumption, what does it take to overcome that presumption? So it's a very interesting case. You can see how it could regularly happen. If we go on to the next slide. And again, what we see a very similar rule which I often rely upon when it comes to tenanted properties. If you have tenants who use another land, a servient tenement in due course, and they acquire a right of way, that becomes part of that inures to a freehold version. And that came up in the rights of light case in Metropolitan Housing Trust Limited against RMC. And really, it was held effectively that inures to the freeholder, but then is demised back down to the tenants. But again, these decisions are difficult to reconcile, and not least because it isn't entirely clear what the underlying rationale is. So if we move on, Niraj, I think that's what we have time for today. We obviously answered a lot of questions about tree roots. There's a huge amount of disputes, and all of these points, Niraj and I were discussing in the webinar, we've all dealt with cases arising out of all of these points. So if you have any questions arising out of today's webinar, then please don't hesitate to contact us in Chambers, on our email, or via our practice management team. Thank you very much for joining us today.
Thank you.